Yes.
Next, Lordship. Lordship, I beg to mention item 8, Lordship. Here I'm for the private response number 3. Item 8.
Yes.
Lordship, I'm yet to file my affidavit, Lordship.
You are for the respondent.
Respondent, Lordship.
Who is for the petitioner?
I'm for the petitioner, Your Lordship.
Okay. So
Kindly allow me 3 weeks' time to file my affidavit, Lordship.
Miss
Rosemary Kikon.
Land Counsel for the petitioner is present. Mr. Poseka for the Land Counsel for the respondent.
Number 3, Lordship.
Number 3. Prays for further 3 weeks' time to file affidavit in opposition. The prayer is allowed. List this matter after 3 weeks.
Lordship, 3 weeks. Lordship, I also beg to mention item 13. 13, Lordship. I'm here for the response.
13.
4. 13, Lordship. Lordship, I filed my affidavit in opposition in the IA today. Lordship, maybe come up on Monday, next Monday for hearing, Lordship, admission hearing.
Okay. So this has been listed for the first time today. Item 13.
Lordship, item 13.
Listed for the first time.
No, Lordship, no, Lordship.
It was listed earlier also.
Yes, Lordship. And I've so time to file an objection to the IA. And I file my objection today. I had in opposition. So if the petitioner is, unless the petitioner is willing to reply, we can take it up for hearing on
Okay.
Monday.
No. Just wait. Let us see. I think you have sought for time earlier also.
Yes,
This is
sir.
only incorporation of some documents.
Yes, Lord.
Oh,
Lordship, I filed my objection today.
My lord, this morning only I've received the objection filed by the private respondent.
okay.
So kindly list the matter on Monday.
Okay, Mr. Poseka Land Counsel for the respondent, submitted. He has filed affidavit no, he has filed objection. Mr.
Tushitamjan.
Land Counsel for the applicant, submitted. He has received a copy of the objection filed by the respondent today itself and prays for some time. He is prayed for by both the Land Counsel for the parties. List this matter on Monday.
Monday, Lordship.
Again on Monday. Okay.
For questioning it.
Lordship, in the meantime, interim may be continued.
The interim order passed earlier shall continue till then. Okay.
Much
Obliged, Lord.
Yes, Your Lordship. Lordship, I beg to mention hearing item number 18, my lord. Lordship, here we are for respondent number 8. Lordship, today my senior Mr. A.G. Momin has some difficulties. So if this matter can come up on Monday, my lord.
Monday. So who is for the petitioner here? Is the petitioner?
Your-
No objection.
Your Lordship, I beg the matter be fixed on Tuesday.
Tuesday.
Lordship, 22nd, we will have difficulties on the 22nd. If it can come up on 24th, then, my lord, Thursday.
Is it okay?
No objection, Your Lordship.
There is pray for by both the Land Council for the parties. Let this matter be listed again on 24th.
Lordship.
Okay.
May I please, Your Lordship, I beg to mention item number 12. Your Lordship, we have received the counter affidavit filed by the state respondent, so I may be granted 3 weeks to file affidavit in reply.
Affidavit filed.
Yes, Your Lordship.
Okay. Miss
Sigmo.
Land Council for the petitioner submitted. She has received a copy of the affidavit in opposition filed by the state respondent and prays for some time to go through the same and to file affidavit in reply if required. Okay. Is
Sure,
prayed
sure.
for come and list this matter after 3 weeks.
Sure.
Okay.
Please, Your Lordship, I beg to mention item number 10.
Then
Yes. 2 weeks may be given to file my affidavit, Lordship. And for respondent number 6.
yes. Miss
Imtila.
Mtila. Pongen, Land Council for the respondent number
6, Lordship.
6. Praise for Father. How much time you said?
2 weeks, Your Lordship.
Father, 2 weeks time to file affidavit in opposition, to which the Land Council for the petitioner has no objection. Prayer allowed. List this matter after 2 weeks. Okay.
I bless your Lordship. Lordship, I beg to mention item number 6, Lordship. Lordship, here we are yet to file affidavit in reply. So kindly grant us 2 weeks time, Lordship.
Why you have not yet filed?
Lordship, last chance may be given 2 weeks time, Lordship.
I'm for the private respondent, madam.
Private respondent. And
Your Lordship will file our affidavit in opposition on behalf of the respondent.
already filed.
Yes.
Okay, they want to file reply.
Yes.
Okay.
Lordship, that may be recorded. Last chance is granted and no further adjournment for filing
Okay.
reply.
Mr.
Nakula M. Konya.
Naplan Konyak, Land Council for the petitioner. Praise for how much time you said?
2 weeks time, Lordship.
Father, 2 weeks time. No, in Konyak, Naplo in Konyak, huh? Land Council for the petitioner is granted. Father, 2 weeks time to file affidavit and reply as a last chance. Stop. Mr.
I examine for
You for?
respondent number 7 to 73.
I examine for 77, 72, 72,
73.
73. And you for?
Renboni for respondent number 4.
For respondent number 4. And okay, now,
Hearing is agreeing for the state.
now for respondent number 1, 2, 3. Okay, are present. Huh? Is prayed for by the Land Council for the petitioner. List this matter after 2 weeks. Okay.
Lordship, let the interim be continued, Lordship.
The interim order passed earlier shall continue till the next date of listing. Okay.
Lordship, I also beg to mention item number 24.
Item 24.
Yes, Lordship. Having item number 24. Let the item may become about 3 weeks, Lordship.
No objection.
Lordship.
Okay, Mr. Okay, Konyak, Land Council for the petitioner. Praise for listing this matter after 3 weeks, to which the Land Council appearing on appearing on behalf of the state respondent, Mr. Angami, has no objection. Prayer allowed. List this matter after 3 weeks. Okay.
Lordship, there is an interim.
The interim order passed earlier shall continue till the next date of listing. Okay.
Deeply obliged.
Please, Your Lordship, may I be pleased to mention petition item number 1, Your Lordship. Here, the fixation pay of the petitioner has been addressed, Your Lordship. However, I have yet to get an official copy. So if the matter can come up after 1 week, Your Lordship, so that I can place the official copy, Your Lordship.
Okay. Okay. As prayed for by Ms.
Leave it, Your Lordship.
Libik. Respondent, let this matter be listed on Monday.
After a week.
Yes. Okay, on Tuesday. Okay.
Adjourned.
Mr. Lordship, I beg to mention item number 19. Lordship, here the senior counsel
Item
19. The senior counsel is in dispose, so let the matter be listed after 2 weeks.
state respondent. Okay. No objection. Miss
Dr. C.
Land Council for a petitioner. Land Council submits that our senior is indisposed, therefore pray for adjournment of the matter for 2 weeks. Prayer not objected. Accordingly, the prayer is allowed. List this matter after 2 weeks. Okay.
His lordship,
Yes.
item 23, hearing.
Yes.
Lordship, this letter will be taken up after 3 weeks and for the petitioner when this petition comes.
So respondent is CGSC.
Uninakum.
Have you informed?
Yes, lordship.
Okay. Mr. What is Amir? Land Council for the petitioner with the consent of the Land Council for the respondent. Prays for listing this matter after
3 weeks.
3 weeks. The prayer is allowed. List this matter after 3 weeks. Okay.
Lordship.
May I please, your lordship, I beg to mention hearing item number 20.
Two
If the
zero,
matter can come up to 3 weeks, lordship.
20.
Yes, 20.
So is there any other private respondent here?
No private respondent.
Okay. No objection. Miss
Asaritsa,
Land Counsel for the petitioner prays for listing this matter after
3 weeks.
3 weeks, to which the land additional AG. Ms. Sukri has no objection. Accordingly, the prayer is allowed. List this matter after 3 weeks.
Lordship, there is interim.
Para, the interim order passed earlier shall continue to the next date of listing. Okay.
Next, Lordship.
Yes.
Lordship, I'd like to mention item 21 and 22 of the hearing, Lordship. 21 and 22, Lordship. Lordship, my senior.
You're for the petitioner.
I'm for the petitioner, Lordship.
Hmm.
Lordship, if it can come up after 2 weeks, Lordship. After 2 weeks,
Your senior is?
Mr. PB Paul,
Okay. He hasn't come.
Lordship, yes.
Okay. Mr. Puseka for the land counsel for the petitioner. Prays for adjournment of the matter for
2 weeks.
2 weeks, to which the land counsel for the respondent has no objection. Accordingly, the prayer is allowed. List this matter after 2 weeks. Okay.
Voice vote.
Thank you, Lordship. Lordship, I beg to mention item number 8, Lordship. Lordship, here I'm yet to file my affidavit, so can you give me some time, Lordship?
Item
Item 8.
already adjourned.
Lordship, item number 14. Here also similar prayer, Lordship.
Affidavit not yet filed.
Yes, Lordship.
Yes. No objection.
No objection.
Ms. Chang, land counsel, land government advocate appearing on behalf of the state respondent, prays for further, how much time you said?
3 weeks, Lordship.
Further 3 weeks time to file affidavit in opposition on behalf of the state respondent. The prayer not objected. Accordingly, the prayer is allowed. List this matter after 3 weeks.
Lordship, here I'm appearing for respondent number 5 and 6 on behalf of my senior, Mr. A. Jimomi, the standing counsel of Gauhati High Court, my lord. So if my presence may be reflected. my lord.
Okay,
In the court
Yes.
list, it's wrongly reflected as PP Nagaland, my lord.
okay.
So if it can be corrected.
Ms. Luzino, land counsel appear on behalf of Mr. A. Zimomi, land counsel for the
Standing counsel for.
And I'm a standing counsel for the Guwahati High Court. Okay,
Lordship, I also beg to mention item number
Mm,
11.
just a minute. The registry shall correct. The registry shall, Mr. A. Jimomi is just for the Guwahati High Court, which has been wrongly listed as PP Nagaland. The registry shall correct and do the needful. Okay, yes.
Lordship, item number 11, Lordship, on behalf of my colleague.
Not yet filed.
Not yet filed, Lordship.
I'm for the petitioner, your lordship.
Okay. So in all the cases, not yet filed, I've noted. So how much time?
3 weeks, Lordship.
for the 3 weeks? Ms. Chen, land government advocate. Appearing on behalf of the state respondent, prays for further 3 weeks' time to file affidavit in opposition. The prayer not objected. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
Lordship, I have submitted prayer for item number 28 from the supplementary cause list, Lordship, on behalf of MD Mr. additional 80. I'm yet to
Two-
receive instructions, Lordship.
Yes, here
From
also
the-
not, here also not yet filed.
Yes, Lord,
Yes, I've seen.
mediate.
But why state is not filing in all the cases?
I'm yet to receive instructions, Lordship.
May I please, your lordship?
Yes.
Lordship, the state has been seeking time for since last year, and lordship, there is an urgency in this matter. Lordship, in fact, here the interim prayer was to be considered after the motion was moved. However, since then they have been seeking time, and lordship, the interim prayer has not been heard, lordship. So there is an urgency, lordship. Lordship, this matter is regarding the here the petitioners are seeking for regularization, lordship. And there is an administrative approval for procurement of the said post vacancies, Lordship.
There is an already administered approval
For recruitment process, Lordship. For advertising the vacancies, Lordship.
okay. Just wait for some time,
Lordship.
okay?
Right.
Just see.
Lordship. Right, Mr. Lordship.
Yes,
I beg to mention item number 5. Pleadings are completed in this matter, so can I use the matter for hearing? We have filed our affidavit in reply on 16th.
ready for hearing.
Yes. We have filed our affidavit in reply on 16 June.
Yes. So why you are mentioning? Wait for some time. Okay, we'll pass order.
Okay,
Yeah.
madam.
Any urgency?
No, my lord, here the pleadings are complete, so let the matter come up in the hearing, is
Okay.
the official court.
Because this, okay. Miss,
Mention no.
but why it is to be mentioned? Order is to be passed. Wait for some time,
Okay.
okay?
What?
Right, Mr. Lordship, I beg to mention the hearing item number 31. Here, my seniors is disposed, so if this matter can be listed after 2 weeks. Lordship.
May I please your lordship?
Yes,
Lordship, there is an urgency in this case. There are 4 or 5 analogous matters. Lordship, the matter relates to, Lordship, the state government had took a policy decision for special recruitment drive for COVID the officers in the medical department who had served during COVID. Then, my lord, the special recruitment drive was supposed to be held, written examination on 26th of August last year. Since then, lordship, in view of the interim order, the matter has been kept pending. Accordingly, on the last occasion, on 24th, lordship, the matter was listed before court number 2. Because of the urgency involved, the Honorable Court fixed the matter to be heard yesterday. But unfortunately, the matter could not be listed because in the meantime, lordship, the state government had advertised for 30 posts of medical officers, written already conducted. So if the petitioners succeed, then there will be complications. So, my lord, it appears Mr. Moa is absent today, but then in view of the urgency, we can fix it Monday or tomorrow or Friday if it is.
so Monday,
Yeah, Lordship.
okay. Miss
Are married.
submitted her senior is indisposed, therefore pray for adjournment. The land counsel for the petitioner. How many petitioners are there? You are for the petitioner, otherwise the rest are respondent, for respondent.
My lord,
There are several writ petitions.
You are also representing the petitioners.
Yes, your lordship, in the item number 29. The WBC number 184.
29.
187, your lordship. Yes.
Okay, this item 28, 29 and 30, this,
29, starting from 29, my lord.
Okay,
29,
okay.
30, 31 and 32.
okay.
31, I think 31 and for the petition.
if lordship, without mentioning the who are petitioners and respondents and the
Okay.
prayer of the parties, if the order is passed, that will become more convenient because all 5 analogous matters.
Okay, the petitioners, the land council for the petitioners shown some urgency, huh? Therefore, pray for
Yeah, I am also
listing this
petitioner.
matter on Monday.
It's okay.
The prayer is allowed. List this matter on Monday
As a fixed item, lordship.
as a fixed item. Okay.
May I pray that as first item on Monday? Praying for lordship indulgence. because
It will be in as a first
the
item
admission
in
policy.
admission.
in
Okay,
the admission-
okay. As a first item in admission column, huh?
Lordship, interim order we allowed to continue.
Hmm?
Interim order we allowed to continue. In item,
There is interim also in item.
item 31.
Stop. Okay, in item 31. Huh? So there is no interim in other item. 29. And in 30? Okay, the interim order passed in item, in WPC 187 and 187 2024 and WPC 239 2024 shall continue till then, okay? Okay.
Much obliged.
from the supplementary cost list for motion, item number 25.
Yes. No one appear. Medovero. Item 25 is none appears on behalf of the petitioner on call. List is matter after a week. Okay.
For motion, item number 26.
This is, yes, what is this?
Your Honor, if I may,
Okay, in person.
in person, yes, Your Honor.
Yes.
Your Honor, we have a very urgent matter to bring before the court. Due to current events, we believe that the safety of our baby is at stake, and we would like the court to intervene to protect the life of the baby.
So you think that your baby is not safe?
Yes, Your Honor. Your Honor, the incidents
Not, not safe in the present hospital.
without the court's intervention, she is at risk. Yes, Your Honor. Your Honor, the events that have happened starting from the 4th of this month till now is not a random incident. It happened before in 2021. And because of the intervention of this very court, only because of the intervention of this court, my baby's life was protected. And so we humbly request the court to once again take steps to protect the baby's life. The same things that happened before is happening again. They have arbitrarily administered prolonged antibiotics, risking her to become antibiotic resistant. She's having multiple infections. She's having infection every month. This same thing happened in 2021, where she was having infection every month. She was.
Are you also a doctor?
Pardon?
Are you also a doctor?
No, of course not, Your Honor.
Okay.
But this is standard medical literature, standard medical procedure. It's not something that is difficult to read and understand. And this is something that has happened. We have seen it with our own eyes. We were there in 2021 when it happened. And she became antibiotic resistant. She acquired a very serious hospital-acquired infection while she was antibiotic resistant because of their negligence, because of their acts.
So according to you, that they are not taking care of your baby
Yes.
adequately.
They are once again giving antibiotics without justification. They have blocked us from entering the ICU, from visiting our baby. They have also blocked
Must
us
be
from.
following the medical or hospital protocols.
Your Honor, we've always been able to enter. How can they arbitrarily, suddenly, when we request for the medical records, and they've refused for the past 2 months to provide us these specific medical records to do with the current incidents? When we have requested for the medical records, when we have requested to the reason why her condition is deteriorating, they have become hostile and aggressive. They have even went to the police station and told the police, according to the police officer, he told the OC, the officer in charge, that they have filed an FIR against us, even claiming physical abuse, Your Honor. Their CCTV shows that that never took place, ever. That is an absolute lie, and we absolutely deny those allegations. They have tried to falsify claims to initiate the police to arrest us.
And on
To-
top of that, they have
Arrest-
restricted our
arrest-
access to the
arrest
baby,
whom?
specifically my husband. One of the police
You-
report is there.
And therefore you have also filed FIR.
Yes, we have filed a complaint. They are doing preliminary investigations.
See, it appears that situation has created the atmosphere of, you see, the disturbance atmosphere, distrust between the parties, it appears.
Yes,
And your baby has been there for how long?
for almost 5 years, Your Honor.
5 years.
Every single thing that they have submitted in this court,
Now-
Your Honor.
Have you thought about over it that the baby be shifted to some other hospital?
Your Honor, in 2022,
Because this kind of a distrust, you see,
yes,
lodging FIR against each other, and you are the patient, parents of the patient.
yes,
Their hospital who is treating. There is no reason to disbelieve the doctor actually.
yes,
But then-
Your Honor,
but
there
then
is.
here in the present case, it appears that some distrust as the situation has been created between the parties. Under the circumstances, is it not proper or safer for you to get it shifted, to think over it, to shift the baby to some other hospital which having better facilities?
Mhm. Your Honor,
Is there any other problem in this case? Other than those?
Your
Any
Honor,
other problem? Why they have created this situation or why you have created this situation?
sorry, Your Honor, what do you mean I've created this situation?
This situation has arisen.
Yes.
How and why? Otherwise, it is not expected. Nor in
This
normal.
situation has arisen
Hmm.
starting on the 4th of this month because we requested to see,
News.
not even a copy, just to
You
see.
have said that
The
since
medical record.
2021 also,
Pardon?
in the year 2021 also.
In the year 2021, my baby was at the brink of death. They refused to give proper treatment to the baby. We had to bring the police because they were refusing to give the antibiotics.
See, for the treatment of the child, and you bring the police also in the hospital.
When the baby's life is at risk,
Hmm.
we must take immediate action to protect the
Have
baby's life.
have you made any effort earlier
Sorry, Your Honor.
to shift the baby to some other hospital?
Yes, Your Honor. The hospital
happened then?
advised us to shift the baby to Ames
Okay. then what
because
happened?
they said that they do not have the facility to take care of a baby with the condition that she has. Ames disagreed. The letter is there on record. They filed it through the union. Ames stated that this hospital has the facility, has all the needs, all the necessities to take care of a baby with this condition, and that there is no need.
The present hospital.
Yes, that there is no need for shifting the baby, and that it's also not. She's critically ill. She's in a critical condition, so it's also not advisable to shift her. And the care that she needs is available in this very hospital. Your Honor, in 2022, the baby was being ready to be discharged. So that time while discussing the discharge details with the head of the NICU, I discussed that if the baby has any further issues, I would like to take her to a different hospital, not this hospital. And he told me, which, Your Honor, I have the audio I can provide. It's not hearsay, it's not, false allegations. I have the audio that I
We will
can
not
provide.
enter into that.
Your Honor, he
at the
specifically
moment.
told me that.
But then if you are making some allegation here,
Your Honor, he told me that if I shift the baby to another hospital in Nagaland, that the babies will be at higher risk than this hospital because the other hospitals do not even hire qualified nurses.
the authority of this hospital told you.
Yes, the head of the department, the head of the NICU/PICU, he specifically told me that I should not shift the baby to a different hospital because the other hospitals, they do not hire qualified nurses and the baby will be at higher risk. If I am not satisfied with this hospital, other hospitals in Nagaland will be even worse. So that made me scared to shift the baby to other hospitals. And then after that, Your Honor, once our savings have been depleted, suddenly they wanted to shift the baby out. They claimed that the baby had a rare disease, and that's why all these things had happened. But Ames said that no, the baby does not have a rare disease. That's not the facts. The fact of the matter is that the baby's condition is this way because of their multiple gross medical negligence, because of all of the hospital-acquired infections. Even now, Your Honor, you passed the order telling them to provide us with the medical records. On that day that you passed that order, Your Honor, I appraised you that the baby was currently having a very serious hospital-acquired infection. And they claimed that we are lying, that we have
Just
no
a minute.
evidence.
Why the records, is it prevented? Why the record has not been provided to the parent?
Your Honor, it has now been
Just
It has been furnished.
furnished.
Yeah, it has been furnished to them.
Now you have heard her submission.
Yeah, my lord, before we go further into the case, they have already hired a lawyer who is in Delhi and they should be appearing before the court.
Your Honor,
In spite of engaging a lawyer, they are preferring to appear in person. They are not medical experts, they are not legal experts, Your Honor.
That is
They are
true. That is
wasting-
true.
Yeah, they are wasting the time of this honorable court.
Your Honor, the counsels are also not medical experts. They also are not aware of all the medical issues that happened to the baby. In fact, I'm sure they haven't read the 10,000 plus pages, which I have. They were not there when all those incidents happened. As Your Honor, my advocate has one foot in the Supreme Court at the moment, so he's a little bit delayed.
So, according to the hospital, you were furnished a copy. Why you are saying you have not yet received?
They furnished it, the copy, after this court passed multiple.
But then
orders.
ultimately you have received the copy.
Now I have, and I have
Then-
submitted it in
And why
IA.
you are submitting?
I have submitted the copy in IA 113, proving that they lied in open court and on their affidavit, still claiming that the baby did not
No,
have.
now you
infection
have
on
received
that
the
day.
copy. Now you have
Now I
received the
have
copy.
received, yes. Your Honor.
Then,
And they lied on affidavit, Your Honor. On affidavit to this court, they lied. They lied during the hearing in open court. They lied saying that we are lying, that the baby never had that infection. And they also lied on the affidavit saying that the baby not had that infection on that very day. But the medical report shows that we were not lying on that very day.
Who told you that baby has an infection?
The doctor told us,
Who?
and we saw the medical report the day before we came to the court. That's why we appraised the court of the current situation of the baby. But the respondents' counsels denied that the baby was having that infection in open court. It's there on, live stream. They lied in open court and then they doubled down and lied in the affidavit. In the affidavit, they also lied, Your Honor.
See, when you receive the copy, submitting before the court that you haven't received the copy. So why to, dig out all those, and that way it created an atmosphere of, distrust. And then you are alleging your baby is under treatment before the hospital only, the said hospital. Certain thing, even if 1-2 days delays, but then ultimately you have received the copy. You should have said that I have received the copy now.
At the time, I did not receive the copy. You can see in the order. Your Honor,
Anyway, so
the
in the
court order
meantime,
also
you-
states that.
Let your advocate appear. So in the meantime.
Your Honor, what
in
about the
meantime,
urgency?
We'll issue notice, you
Yes.
file affidavit.
Yes.
Okay, the prayer is to proceed,
Your Honor,
initiate proceeding under sections 379. Okay. Yes.
Your Honor,
Give-
IA
yes.
1114, Your Honor. This is very urgent, Your Honor. The other IAs, I have no issue with adjournment for all the other IAs, but IA 114, this is for the life of the baby. This is to protect her from becoming again antibiotic resistant, again at the brink of, because when that happened in 2021, they did the same exact things as they did now. They became hostile. They restricted us from entering the ICU. They restricted us trying to confiscate our phone. They are doing the same pattern, Your Honor. The same pattern is happening again. And that time, we ourselves had to search for the antibiotics, and we got it from a doctor acquaintance from Delhi. The doctor sent the antibiotics to the hospital, to this hospital. Only because of that, her life was saved. And because of the intervention of the court, that the Honorable Justice Kakito Sema instructed them that they are not to put the baby's life at risk anymore, that they are to follow the court order and continue providing the treatment that the baby needs in order to survive. So only because of this court, the baby was saved.
Whatever may be, land council, land standing council for the hospital, whatever may be, the baby, you should take care of the baby.
We are doing that, my lord.
Hmm.
For the past more than 4 years, the baby is still alive.
Your Honor, arbitrarily giving antibiotics, withholding, suppressing and withholding evidence, withholding medical records, that is not taking care of the baby. Multiple lapses in hygiene, that is not taking care of the baby. NG tube, which caused internal damage and bleeding, that is not taking care of the baby. How can you say that? How can you possibly stand there and claim that you're not even fulfilling the bare minimum medical protocols and medical requirements, the duty of a hospital?
Why
Even the basics you're
why
not
in this
providing.
IA you have implemented so many people, even you have implemented the aims also,
Your Honor, that's just a
And-
cause list of.
and the advocate also in the IA.
Yes.
Yes, Your Honor, because those are all the parties within the
No,
case.
they are not, they cannot be party in the IA, because IA is, you see, your IA prayer in the IA
Yes.
is different, something different from the writ petition.
Okay, I apologize, Your Honor, I wasn't aware of that, since the IA also
No, that
contains
is
the
why,
whole cause list, so
that
I
is
was
why,
misinformed.
take the assistance of the advocate. You have an advocate.
Yes, Your Honor.
My lord,
Yes.
another point which I would like to submit for this honorable court is, till today, they are not paying their dues. Hospital bill have crossed more than 1.25 lakhs. They are not paying that. On the other hand, they are coming before this honorable court with IA after IAs. The last two IAs, copies of which have been served to us yesterday, we have just gone through this, and I seriously doubt the maintainability of these two IAs. One is filed under application, and application is filed under section 379 BNS, and the other one is for seeking urgent protective directions against retaliation, suppression of evidence, and medical negligence. Your Honor, in a writ jurisdiction, this honorable court, I seriously doubt, have the jurisdiction to entertain these two IAs. We are not in a consumer court, we are not in a civil court.
If case made out, we can direct the chief judicial magistrate.
Okay.
We can just for preliminary inquiry, and if found, then can we forward it to the chief judicial magistrate
My lord.
to proceed with the case?
My lord.
No problem with that.
Okay.
Because the trial cannot be done by this
Yes,
court.
yes.
Only the
That's what
preliminary inquiry based on the, of course, the submission affidavit
Yes,
and then the report if there is any. So based on that, this court can proceed.
my lord.
But then is it the case? Because there is the bills has not been paid.
Yes. Your Honor,
So you have been alleged that, retaliatory action has been taken.
Yeah.
Is it because
yeah.
the parents are not paying the bills that you are preventing the parents from entering telephonic call, etc.?
Your Honor.
In that case, this court will not allow you,
Yes.
if that is the case. But why you are not paying the bills?
Sorry, Your Honor.
Why you are not paying the bills?
Your Honor, we have depleted all of our savings. And this court has passed the order stating that this court will have a hearing, a proper hearing, looking at all the evidence and come to the conclusion of who will have to pay the bill and how much. So that day will come. And if this court says to pay the bill
Who will pay the bill means?
There's an order. In 2021, the court passed the order stating that as far as the matter of the bill, the court will decide at a later date. The Honorable Justice Kakito Sema also instructed them that they are not to pursue the matter of the bill in any lower court that.
Please don't take the name of the.
Okay, I'm
judge.
sorry, Your Honor. But they went ahead and
You
filed.
mention the order dated. Oh.
They went ahead and filed a case in the district court for the bill, despite the fact that it's already here in the High Court. The bill matter is already in the High Court. The district court ordered them that in order for the district court case to continue, they must bring a court order from the High Court stating that the High Court will not hear the matter of the bill. Only then can the District Court hear the matter of the bill, as it's the lower court.
Your Honor, there is no such order.
Yeah.
It's of the record.
It's of the record.
Yeah.
See,
And
let your advocate represent your case.
Yes, Your Honor,
Okay.
but what about the
See-
urgent matter, Your Honor? We are not able to go inside the ICU.
Your Honor,
They are confiscating our.
that's not true.
That is true, Your Honor.
Your Honor, hospital has got its own protocol. There
Which
are
they have
certain-
never enforced
there are
for
certain-
4 years plus, have never
Yes,
enforced the
We
protocol.
have been accommodated.
It's
No, see, the
military.
just a minute.
Yeah.
The vegetation,
Yes,
the permission should be given to the parent.
that's correct,
Normal,
Your
normal
Honor.
vegetation, of
Yes.
course, subject to the protocol,
Yeah.
subject to the, of course, the
Yes.
protocol.
We are doing that. All this.
So
while
that
we have been-
minimum, you see, that visit,
Yes,
normally which the one parent should be allowed, that
Yes.
should always allow.
yes. Your Honor, in the PICU,
Hmm.
their child is not the only child resident in that ICU. There are so many other children in the ICU. And there's a certain visiting hours. If they are following that, we have never stopped that. We have stopped them just recently because they are coming not within that visiting hours.
And so there is allegation also, because they have lodged FIR and you have also lodged FIR.
That's
And then
for a
probably,
different issue.
probably under circumstances,
Yeah,
the CCTV footage, all this are to be preserved
Yes,
for the time being.
yes, Your Honor, we humbly request the court to pass the order to let them preserve the CCTV. Because their false allegations against us of abuse, physical abuse, even they alleged, only can be proven with the very CCTV which they hold. If they delete it, they can just continue these false allegations and there will be no evidence.
Now, since you have also lodged FIR, they have also lodged FIR, probably the police must have visited for
Yes.
preliminary inquiry or in
for,
investigation,
yes, so far,
must have asked you to preserve it.
yeah, no regular case has been registered,
Not registered.
not registered.
Okay.
Maybe preliminary investigation is going on.
Hmm.
Yeah,
Must have been instructed
yes.
not to disturb all those records.
Your Honor, we believe that they will never provide that CCTV. It's been over almost 5 years. They
Why you
always
require,
refuse to
why you
provide the
require that? The
CCTV.
police will collect it.
Yes, Your Honor. Your Honor,
But agent, where you visit, why you should also record all those in your.
Your Honor, we have a legal case ongoing. You see, they have falsely accused us of harassment, of even physical abuse. Physical abuse, Your Honor, a very serious allegation. That's criminal charges, Your Honor. And how can we defend ourselves against their allegations? Only because we are keeping records of all of the interactions. That's the only way we can protect ourselves.
And under such circumstances, the best would be that you shift your baby to somewhere and let the medical doctor examine it.
Your Honor,
If
they
it
have,
can be shifted or with the help of the state.
they have in IA 21, they have requested that
And
experts will come.
in the meantime, you at least deposit 50% of the bills.
Your Honor,
Hmm.
that is unreasonable, Your Honor. The only reason why the bill has reached this far is because of all their negligence. Without their negligence, my baby would have been discharged and been at home. Because of their negligence, the bill has reached this far. So how can we be held responsible for the bill, Your Honor?
So in the writ petition, there is allegation of their negligence.
In the writ petition, it's all about their negligence. Everything is there, Your Honor. And all
Then
the way up to
this need to be-
2021.
Then this need to be
You-
clubbed together along the writ petition, this IA also.
My lord, in
Yes.
the original writ petition, all their prayers have been deleted regarding. the
That
case.
was,
Okay.
Initially, they have filed a case even against the individual doctors,
Hmm.
which have been deleted by this honorable court.
that's not true. You can read the order. It was deleted
Is there
by the
proof of-
advocate. The advocate requested the court for deletion of the prayers
Your
without our
Honor,
knowledge or consent.
Okay, well,
For this. or
okay,
we-
this IA also will be listed along in the writ petition. And in the meantime, we'll issue notice. You file affidavit
Yes,
detailing the claim. The claim is that. Huh?
Your Honor, my only humble request is that you passed the order today that they do not confiscate our phone at the door by the security guard, that we are allowed to continue to protect ourselves and protect our daughters' rights by keeping a record of every interaction, so that no more false allegations can be lodged against us in the court or in the police.
Miss, you are?
Ms. Barbara Yunus, petitioner number 2.
Okay, Mr. Tazanguli and Miss So-and-so, petitioners in person. Also heard, Mr.
Just
Hmm. Then you are standing counsel or a,
for
for,
respondent number 1.
okay, Lana counsel for the respondent number
1.
1. No, because you have impleaded the unnecessary party also. You let your advocate appear.
Yes, Your Honor.
So this need to be
Amended, Your Honor.
delayed. The
Okay,
name
Your-
of this AI aims advocates.
Yes, Your Honor.
And here in this case, state of Nagaland should also be, cannot be a party because this is, you are praying for the proceedings.
Yes, Your Honor.
So let them be present. We'll list it again on Thursday. Let your advocate represent you.
Yes, Your
Because
Honor.
we cannot issue notice to all this, which is unnecessary
Your-
party, okay?
Your Honor,
But then those order will be passed, okay? On the, that will be day after tomorrow, okay? The order,
yes,
including the notice. And then the restriction. And then also, since you have already received the copy of the medical documents,
Your Honor,
yes,
item number 17 in today's post list is the main writ petition.
Okay.
Listed for hearing. So they may be posted on the same date as well. Item number 17.
your prayer is to installation of CCTV camera at the beside of baby Adriana. Is it possible? In the hospital, the prayer, installation of CCTV camera at the beside of baby 24/7
Your Honor, already CCTV is there,
It's already there.
is there.
but we have no access to it. And
Yes.
since the baby, we're not
It is in
asking
the safe
for,
custody. It is in the safe custody. That's good.
no, Your Honor.
Immediate case for disorder.
Your Honor, we humbly request,
Footage of the patient, ensure protection of the petition rights. Okay, so
Your Honor, we humbly request that at the very least
Okay.
today, the court,
let this
Please
mat-
pass the
let this- Let this matter be listed on Thursday. No, because this notice we cannot issue to these people.
Your Honor, just so that we can defend ourselves, let them not confiscate our phone at the door. Just for defending ourselves against their false
No.
allegations of physical abuse, harassment, and so forth. They will continue to do this. And they have no legal
The
grounds to block us
phone
from
has been-
audio recording our conversations.
Your phone has been confiscated or
Yes, at the door.
not yet given?
Pardon?
Not yet.
No,
given.
they give it once we come out.
Okay.
They don't want any
My lord.
No,
records
till day
of
after
the
tomorrow, till day
conversation.
after tomorrow only. Let your advocate be represented, you, because these parties are necessary and not a necessary party. We cannot issue notice on to these people.
Your Honor, as long as we cannot record our interactions, which is defending ourselves, we cannot enter to see the baby, because if the doctors are
That
there,
order will be passed.
they
That
might
will-
cause allegations
We'll
once again.
pass order on day after tomorrow.
Okay, then, thank you, Your
Will
Honor.
allow you to visit and then allow directing the
During
hospital.
visiting hours.
Yes, during visiting hours only, of course, subject to the protocols of the hospital. Okay, let this matter be along with,
My lord.
may be listed along with the writ petition, huh?
My lord.
Item number
17.
17,
My lord,
day after tomorrow, huh?
we have also
Thursday.
filed one IA 85 of 2025, where notice is yet to be issued to the respondents, to the petitioner with petitioners. this IA 85 is pertaining to deposit of 50% of the bill amount and
Oh,
deposit of.
There is already the direction.
Yeah, no. A petition is there already, IA 85 of 25, where we have.
When it was filed?
In the month of May, Your Honor. And on the last occasion, no notice was issued.
Okay,
And
along with
this is
item
still
17, huh?
pending. Yeah. IA 85 of 25.
Okay.
Here we have prayed for appropriate direction to deposit 50 lakhs pending disposal of the writ petition and. also-
You file a mention memo to get that matter to be listed along with this
It's all
on Friday,
already-
on Thursday.
Yeah, in today's.
Where do we pass order?
Item number 17. No,
In 17?
Yeah, 17. It's all listed.
But already listed?
Yes.
Okay, that notice also will be issued on then
Yeah,
on
85.
Thursday, same. Okay,
Multiple.
we'll clarify. Huh? Okay.
Thank you, Your Honor.
For motion, item number 27.
May I please, Your Lordship?
Yes.
Lordship, here the petitioner is seeking for alteration or modification of the meeting minutes issued by the Deputy Commissioner of Kifri, Lordship, and also seeking for compensation under the new Act of 2013, that is the Act of the Right to Fair and Compensation 2013 Act, Lordship. Lordship, here the brief fact is that in the year 2011, Lordship, the petitioner late father entered into an agreement with the additional deputy commissioner, that is the respondent number 3, with the condition that the land will be donated on the condition to provide an appointment, Lordship. So in the year after the agreement, there administrative rest house was built in the land donated, Lordship. So the petitioner's family applied for the post. However, Lordship, her prayer was not considered, so they approached this honorable court by filing WPC seeking for the appointment on the basis of land ownership. However, Lordship, this honorable court disposed of the writ petition with the direction, basing on the OM of 2005, that there is no further appointment after the 2005 OM, Lordship. So this honorable court directed the president respondents to pay the compensation for the land donated, Lordship. So after this, Lordship, after this order, the order is at.
Consider for appointment rejected.
Yes, Lordship. The conditional order for appointment was rejected by this honorable court by order dated 12/9/2023, which is at page 18, Annexure B, Lordship.
Yes.
So here in this rate, this honorable court.
Take a step
Yes.
to pay necessary compensation. It was assessed.
Lordship already, Lordship.
Assessed.
Yes, Lordship.
So then what is your grievance now?
Lordship, here now the demand is that after this writ petition, we gave a covering letter and the process was made. And the state government, in fact, they also came for cross-checking and inquiry regarding the land. And with that, the meeting minute which I have sought for alteration is at page.
How do this High Court alter the meeting minute?
No, the state respondents, Lordship. Lordship.
Yes, page.
That is at Annexure F, Lordship.
You can challenge the minute, but then how we can alter?
Modification, Lordship, to the extent of the
If it
amount,
violates
Lordship.
your fundamental rights.
Lordship, that is
Page-
at page 36, Annexure F. So Lordship, here the state respondent came to a conclusion that the amount is to be paid, it's 1,92,000 only.
Okay, so
For-
what is the area?
Lordship, the area is 40 by 60, Lordship. That is 40 into
Feet,
50,
feet.
yes, square feet, Lordship. That is 2,400 square
But
feet.
reasonable.
It's in the minute, Lordship.
It's not reasonable.
Yes,
According to
Lordship.
you.
In fact, for us, it's because they have been using the land since 2011, Lordship.
It's
And-
land only, not the building.
Not the building, Lordship.
So
the
then-
yes, Lordship, we agree that the building was built by the, but the condition that they donated the land was
It was
to give
given to the public
appointment.
for public purpose only.
Lordship, that we
Donated,
agree.
you have donated.
Lordship, the
After
was-
donation, how can you claim?
Lordship, the agreement is very clear that with the condition to give appointment, grade for appointment, Lordship. So that is the only ground that we
But
gave the
with
land.
subsequent notification, that is not allowed.
Lordship, that is why we also came to the understanding to take the
Then
compensation.
the
Lord.
what remained is compensation. Compensation, this is not adequate according to you.
Yes, Lordship, it's a very meager amount, Lordship, comparing to the years that we have.
How do
made.
we increase then? If they have assessed, the government has assessed
It's the
as
Lordship.
per the present rate.
Yes, Lordship, that we agree, but this is not as per the Act of 2013, Lordship. The new act which has come into force in the year 2014, Lordship. So. not
You are
the-
claiming as per
under
the new act,
Lordship.
when the land was given.
Though the Lordship, though the land was given in the year 2011, Lordship,
Then-
the
Hmm.
compensation was to be given only after this writ petition was disposed, which is on 2023, Lordship. So here we are agreed by the meager amount, Lordship.
Yes.
My lord, at this station. let
Will
that
issue
notice-
issue notice? Okay.
Yes.
Mm.
I'm bring for respond number 1 from.
Miss Mikael, Land Council for the petitioner. By filing this writ petition, the petitioner seek direction to the state respondent to alter, modify this may not be possible, alter, stop, modify the meeting minutes dated 18/6/2024 and compensate the petitioner as per the right to fair compensation and transparency in land acquisition, rehabilitation, and Resettlement Act 2013. And also to pay 18%. What is this, 18%?
So the 18% per annum, that is for the interest rate for the years that have been
Okay,
less.
okay. Then to pay 18% interest per annum. With 18% per interest per annum, huh? Okay. Issue notice. Returnable by 4 weeks, stop. Since Mr. Tibapo, Land Council, Government Advocate, accept notice on behalf of all
Yes.
the respondents, no formal notice need be issued, okay? Okay. However, the petitioner shall furnish requisite extra copy to the landed, Mr. Tibapo, Land Government Advocate, during the course of the days, staff, huh? List is matter after 4 weeks. You file affidavit
Yes.
within 4 weeks,
Okay.
okay?
Much obliged.
Much.
Lordship.
For admission, item number 2.
Yes. Affidavit not yet filed.
That is my lord.
Yes.
My lord, mentioning on behalf of the respondent number 6. This is for a private respondent, my lord.
You are for respondent number 6.
Yes, my lord. For the
File wakalat nama.
No, my lord.
You
Till
file wakalat nama.
Yes, my lord, till that I haven't.
Your name already reflected here.
Yes, my lord. My lord, till that I haven't received any instructions, and moreover, I couldn't meet any communication with the private respondent, so I'll be withdrawing.
Okay, you want to withdraw?
Yes, my lord. Because I couldn't meet any communication with the private respondent till then.
Then you have to take steps, huh? You have not yet filed wakalat nama. Okay. Yangarvati appeared. Okay. Mr.
Jingyang Paul, my lord.
Land Council, appearing on behalf of Yangarabati. Counsel who earlier appeared on behalf of the respondent number 6 submits that on the verbal instruction they put appeared. However, no wakalatnama has so far been filed. And since they have not received any instruction, further instruction from the respondent, they want to withdraw their name from the case. Stop. Huh? You have received the copy also probably. Then you have to return the copy to the respondent number 6. Return this copy of the writ petition to the respondent number 6. The counsel shall return the copy of the writ petition which they have accepted earlier to the respondent number 6. Within 2 weeks. Huh? Okay. In view of the above, the counsel, the prayer is allowed. The name of Mr. Yangarwati as Lana counsel for the respondent number 6 shall be struck off from the course list. Okay. Okay. Miss Lana counsel for the petitioner is present. Stop. Okay, Mr. Yes, Angami appear. You are not yet filed affidavit.
I filed.
You have filed? Okay. Lana counsel for the state respondent is also present. Stop. In view of the withdrawal of the Lana counsel who earlier represent respondent number 6, the petitioner shall take fresh steps upon the respondent number 6 by a registered post with AD as well as by usual process within a week from today. You take fresh steps?
Yes, Your Lordship.
Okay. List is matter after 4 weeks.
Right.
Yes, Your Lordship.
For admission, item number 3.
May I please, Lord?
Yes.
My lord, the dispute between the petitioner and the private respondent has been settled by the Deputy Commissioner on 14/7/2025. The lordship, may I kindly see the order. May I read, my lord?
Yes.
Order dated 14/7/2025. Sri Alizo Kense versus S. Pukuto Zumomi. Order, whereas a complaint had been filed by Sri Alizo Kense alleging that Sri S. Pukuto Zumomi had started earthworks and land filling on a fishery bond under his land covered by Pata number 221, Tag number 39, Mozart number 3 of Purana Bazar, AK. And whereas during the intervening period, an application dated 14/10/2024 was received by the office from Mr. So-and-so, wherein it is alleged that Pata number 221, Tag number 39, standing in the name of Sri So-and-so, was mistakenly submitted as dispute land against Sri So-and-so, and that the same should be under Pata number 1136, Tag 39, 1687, which is standing in his name. And whereas taking cognizance of the matter, an order for joint spot verification was issued dated 01/10/2024. However, since Mr. So-and-so could not be present on 9/10/2024. The joint verification was fixed and carried out on 12/11/2024 in the presence of ESC Revenue, TLRSO, TB, and the parties concerned. Accordingly, by white letter dated 11/3/2025, the DLRSO submitted its spot verification report. And whereas consequent thereto, someone was issued dated 16/4/2025 for a hearing to be conducted on 22/4/2025. During hearing, Sri so-and-so submitted that the disputed land falls under his pata number 1136, tank number 39/1687, Mozar number 3, under Borna Bazar, AK, area measuring 4 Pika 13 Lisa, which he had purchased in the year 2018. While Sri so-and-so submitted that the disputed land which Sri so-and-so is purportedly claiming is under his pata number 895, tank number 104/1382, Mozar number 3, under Borna Bazar, measuring 10 Pika 1 Katha 6 Lisa. I heard the submission produced the case record, the document filed by the parties concerned, and the joint survey verification report dated 11/3/2025. What has transpired from the present case is that both the parties are claiming the plot of land in disputed measuring 7 Pika, 1 Kata, 16 Lisa, based on their respective patas. This plot of land, as per the survey report, falls under tank number 39, 104, and 364. However, since the land under tank 364 with an area measuring 1 Pika 19 Lisas does not fall either under pata number 1136 or pata number 895. Sri so-and-so and Sri so-and-so are restrained from making any further claims in this regard. As regards the remaining plot of land measuring 6 Pika 17 Lisa, Sri so-and-so is entitled to that portion of an area measuring 2 Kata 9.5 Lisa, falling under tank number 39/1687, while Sri so-and-so is entitled to the portion of land measuring 5 Pika 3 Kata 7.5 Lisa, which falls under tank number 104/1382. As corollary, the ESC Revenue Head TB, DLRSO, Dimapur, and parties concerned are directed to put 1 pillars as per demarcation shown in DLRSO Dimapur Spot Verification Report dated 3/2025. The same should be completed within a period of 7 days from issue of this order.
So, Mr. Pasik, so this is a settlement
Lordship.
agreed with by
Lordship.
both the parties.
Lordship.
Okay,
This, the petitioners agree, but
agreed.
we can close the matter.
Okay.
I received the order this morning, so can we allow me some time to
Get this on Thursday then?
Lordship.
Okay, my lord.
Thursday.
Okay. Heard, Mr. Pasik, Land Council for the petitioner.
Lordship.
Also heard Mr. Dibapom. You are respondent. Okay, Dibapom for the state respondent and Mr.
1, 2, 3, 4.
1, 2, 3, 4, and Mr. Lakti for respondent, private respondent number 4. Staff. It is submitted that the matter has already been settled with the intervention of the Deputy Commissioner Dimapur, Nagaland, by his order dated 14/7/2025. However, Mr. Lakapom, Land Council appearing on behalf of the respondent for submits that he has just received a copy of the order and would like to go through and confirm from his client. Therefore, pray for the adjournment of the matter for the day. Staff. Let's pray for Kama, list this matter again on Thursday. Okay.
Much obliged. Like my lord.
For admission, item number 4.
May I please, my lordship?
Yes,
Lordship will be filing our affidavit in reply to both union and state during the course of the day.
okay. Affidavit in reply, you want to file?
Yes, lordship.
Okay, Mr.
Yakasumi.
Your name is there? Yakasumi,
Yes,
land
Lord.
counsel for the petitioner. Some state. The petitioner is filing affidavit in reply during the course of the days. Stop. Mr. or Miss Cheng. Land counsel for the state respondent, land government advocate appears on behalf of the state respondent number 1, 2, 3. And Mr.
Chingyam Home on behalf of Your Honor for respondent number 5.
Cheng for up to 4, 1 to 4, and Mr. Chenglia
Chingyam Home.
for respondent number 5 are also present. In view of the submission made by the land counsel for the petitioner, let this matter be listed after 2 weeks. Okay.
For admission, item number 5.
May I please, lordship? My lord, here the pleadings are complete.
Okay.
So let the matter be covered.
Hard miss
Motion.
land counsel for the petitioner and Mr. Thibapom for the state respondents. Stuff. It is submitted that the pleadings are completed and the matter is ready for hearing. Stop. In view of the above, let this matter be listed for hearing after
2 weeks.
2 weeks. Okay.
Lordship, there's an interim.
Stop. Para. The interim order passed earlier shall continue till the next date of listing. Okay.
Much obliged. For admission, item number 7.
My pleasure.
Yes.
Your Lordship, I think the submits that I have to make some addition to particular, more particular to prayer. To question set aside. More particularly, the respondent number, private respondent number 5. I think that is selected as a VDP secretary.
You are for the petitioner.
Yes, I did.
You made a prayer earlier to file affidavit in reply.
Yes, my lordship, your lordship.
Now your prayer is?
My prayer is to addition for more particular questions set aside. Number 1. Order
Addition?
to add some words, my lord.
Oh, to amend the
Yes.
petition.
Yes.
They have filed their affidavit already.
We raised some objections with regard to the effective petition. Because
You have to make a proper application then. In that case, let them also. You make a proper application so that they file objection and will pass order. You have to make an application for that. Here in the petition, we cannot, because they have already filed affidavit. Had it been before filing affidavit and you make a prayer for amendment of the prayer,
Yes.
could have, but then now since they have already filed, it will be difficult now. You make a proper application for amendment of the prayer, okay?
My lord.
Or any other amendment in the writ petition. You make it, and then what about the filing of affidavit in reply?
My lord, I'm not filing the affidavit and reply,
Okay,
except to
Mr.
add some words of the prayer made on.
Mr. Jaren Muli, land counsel for the petitioner. Submits that the petitioner is not filing affidavit in reply. However, he prays for allowing him to file application for amendment of the prayer in the writ petition.
More particular,
No need to mention. You make a mention there in your application. Okay.
my lord.
Okay. As prayed for, comma. List this matter after 2 weeks. Okay.
My lord.
Okay. Then they are present, huh? Mr. To Mr.
and for respondent number 5.
Okay. Land Council for the respondent number 5. 4, okay. Okay, state respondent number 1, 2, 3, and Miss for respondent number 4, and Mr. for respondent number so and so for respondent number 5 are also present. Okay.
One rest.
For admission, item number 9.
Yes, affidavit not yet filed.
My lord, I'm for a private respondent for the respondent number 6. I've already
Or who has not yet filed? You have already filed.
Yes,
Okay, you?
I have sought for some instruction, however, I need a receipt, so if 3 weeks time, can be granted to me, Lordship.
Instruction already received.
Yes, Lordship.
Okay. Miss,
Rosemary Gikon.
Land Council for the petitioner is present. Okay. You have also not yet filed. Oh, already filed, okay. Okay, Miss.
I'm for the state, Lordship.
Okay. What was your name? I just forgot.
Pichano.
Sorry, Pichano. Land Council appearing on behalf of the state respondent number 1, 2, and 3.
1, 2, 5, Lordship.
Submits that she has received an instruction one, two, 3, and 4. 5 also? You are for 5. Only 6. Okay. She is representing 1 to 5. Huh? Some is that she has received an instruction to file affidavit. How? Affidavit. Means pray for some more time to file affidavit. Huh?
Your Lordship, there is an interim.
Okay. So it receives an instruction, however, prays for some more time to file affidavit. The prayer is allowed. List is matter after 3 weeks.
Lordship.
Your
3
Lordship,
weeks.
there's-
Mr. Land Council for the respondent number, private respondent number 6 is also present. Stop. Para. List is matter after 3 weeks. Stop. The interim order passed. There is interim.
Your
The
Lordship.
interim order passed earlier shall continue till the next date of listing. Okay.
For orders, item number 15.
May I bless the Lordship?
Yes.
Lordship, I made a receipt instruction, so 3 weeks time, can be granted to me, Lordship.
Okay. What about the service notice upon the respondent number 4?
Lordship, I have taken steps and I'm yet to file my affidavit to that effect, Lordship. I'm given some 2 days time to file my affidavit, Lordship.
Affidavit, okay, you have taken
I've taken steps.
by Dusty Service?
Yes. Lordship,
Okay.
as per order 2625.
Okay.
So the
Mr. Jose Forte, Land Council for the petitioner. Some is that although he has taken steps upon the respondent number 4 by way of Dusty Service, I will prays for some time to file affidavit to that effect. Stop on. Ms. Bichano, Land Council appearing on behalf of the state respondent number 1, 2, 3. Some is that she has received an instruction and prays for some time to file affidavit.
I'm yet to receive instruction,
But
Lordship.
yet to receive.
Lordship.
Some is that she is yet to receive instruction and to file affidavit. Therefore, pray for some more time for the 3 weeks time. Okay. In view of the above, and is prayed for by the parties, let the matter be listed after 3 weeks.
Lordship.
I would like.
Lordship, my lord.
For orders, item number 16.
Yeah, Mr. Lordship. Lordship, I'm back to mention on behalf of my colleague. I'm yet to receive instructions, so can you grant me 3 weeks time, Lordship?
What about this ID card received in respect of? Okay. So when did you take steps upon the respondent number, the rest of this
On
respondent?
4/6/2025.
Okay, so can be waited, no?
Yes. Your
Okay,
Lordship.
Miss, what was your name?
Rosemary Kikon.
Hmm?
Rosemary Kikon.
Rosemary Kikong,
Yes,
Lani
Your
counsel
Lordship.
for the petitioner is present. The office note dated 14/7/2025 reflect that ID card received in respect of respondent number 26. However, the service upon the respondent number 4/2/25 is still awaited. Staff, Miss Chen, Lana Counsel, Lana Government Advocate, appearing on behalf of
Mr. Achung Lee, Lordship.
Mr.
Achung Lee.
Achung
Achung Lee.
Lee, Lana Government Advocate for the state respondent number 1, 2, three, submits that she is yet to receive instruction and prays for further 3 weeks time to file, to receive instruction and to file affidavit.
Your Lordship, we served on 4/6/2025, not 14.
Okay. No, this is, the office note reflect on 14,
Alright, Your
although
Lordship.
you have taken steps on 6. Okay. In view of the above, and as prayed for by the parties and the Lana Council for the respondent, let this matter be listed after 3 weeks. Okay.
Much obliged, Your Lordship.
Finish. Okay. Too early.